Hello, everyone. My name is Adam Ernett. I'm the IP Law Fellow with the Center for Intellectual Property Information and Privacy Law here at the University of Illinois Chicago School of Law. I am pleased to introduce Mr. Gary Friedlander, Ms. Rena Lee, and Mr. Ignacio de Castro Lamas. And I will bring them up to the stage here as I briefly introduce them. So Gary, you can turn on your camera and your microphone. Thank you. Perfect. So, Mr. Friedlander is the interim director for the Center of IP Information and Privacy Law here at the University of Illinois Chicago. Ms. Rena Lee is chief executive at the IP Office of Singapore, and Mr. Ignacio and Mr. De Castro Lamas is director of the IP Disputes and External Relations Division at Wipo Arbitration and Mediation Center. So everyone, please join me in welcoming Mr. Friedlander, Ms. Lee, and Mr. Castro Lamas for our welcoming remarks.
Thank you, Adam. We've got quite a international audience, so good evening, good afternoon, and good morning. It's my pleasure to welcome you to Thinking Internationally about IP and Dispute Resolution. This webinar is co-organized by the Intellectual Property Office of Singapore, the World Intellectual Property Organization's Arbitration and Mediation Center, and the IP Information and Privacy Law Center at the University of Illinois Chicago Law School. I encourage you to visit the websites of all three organizations for a wealth of information on all things IP, including the upcoming IP Week event being held in Singapore in just a few weeks. While I understand the use of alternative dispute resolution for patent disputes goes back to at least 1834, it was really in the 1980s and 90s that ADR programs grew at an unprecedented rate, offering an additional path for companies and individuals to seek justice. ADR can offer speed, reduced costs, and helps alleviate court and public agency dockets. ADR also provides courts an alternative way to resolve disputes for cases that can best be handled outside of litigation. Wipo literature, for example, notes that family courts were early adopters of mediation, and I could attest to that as well, to the effectiveness of ADR to resolve many family, neighbor, small business, and labor disputes, having served for 7 years as a mediator for the Center of Conflict Resolution in Chicago and the Illinois Department of Human Rights. Today, ADR is widely used internationally with global and highly respected practitioners and arbitration and mediation centers located around the world. You will find ADR provisions in many international commercial agreements, providing a trusted neutral dispute resolution path backed by global convention, which helps enable global contracting and trade. Today's 2-hour panel discussion brings together leading experts in IP alternative dispute resolution from government, private industry, and academia. I am a bit biased, but you'd be hard-pressed to find a more distinguished group of panelists. It's now my pleasure to introduce you to Rena Lee, Chief Executive Officer of the IP Office of Singapore. Rena?
Well, thank you very much. Gary. Good morning, good afternoon, and good evening to all participants. It's my pleasure to be here today. Mr. Friedlander, Professor Lim, Mr. De Castro, Dr. Lai, distinguished panelists, ladies and gentlemen. The Intellectual Property Office of Singapore, also known as IPOS, is very honored to co-host today's webinar on thinking internationally about IP and dispute resolution. This is an associate event of IP Week that Mr. Friedlander referred to. And IP Week is an annual event that is hosted by IPOS, bringing together different experts across the globe to explore trends and cutting-edge issues in the IP landscape. This year, our theme is Ideas to Assets, Charting Our Future with IP. And it will see discussions on a wide range of topics, including current hot topics like the metaverse, artificial intelligence, and as well as non-fungible tokens. So everyone here is warmly invited to join us in Singapore or virtually for IP Week happening from the 5th to 7th of September. And I'll ask colleagues to post a link to our IP Week website where you can find out more. Last year in Singapore, we launched the Singapore IP strategy for 2030. And a key plank of the Singapore IP strategy for 2030 is for Singapore to be a choice venue for IP dispute resolution. And one of the fundamentals for us to be that choice venue is to provide that full suite of dispute resolution services. And these are currently available in Singapore today, including the Singapore International Commercial Court, or SICC, where disputing parties are free to engage lawyers from around the world. The Singapore International Arbitration Centre, which has been recognized in a White and Case survey last year as the world's second top arbitral institution, as well as the Singapore International Mediation Centre. Specific to IP disputes, we're very happy to host the Wipo Arbitration and Mediation Center, which today is the only office outside of Geneva for the center. We have also established the Maxwell Chambers, which is the world's first integrated dispute resolution complex, housing hearing facilities as well as ADR institutions, and providing services for 24/7, including hearing and preparation rooms that allow for in-person, hybrid, and virtual hearings, as well as supporting services. But facilities and services are not the only elements to be a world-class dispute resolution hub. We are also continuing to find ways to provide relevant dispute resolution services which can cater to the ever-changing world. And one of the ways that we are doing so is building a ready list of experts in a range of technology areas to aid in dispute resolution in today's digital world. And these experts can help the decision maker or the facilitator to better understand and assess different technical aspects of the case. In addition, the SICC, or the Singapore International Commercial Court, has recently established a specialist technology, infrastructure, and construction list dealing principally with complex issues, including technology-related disputes. Beyond the services, IPOS, together with the Singapore Mediation Centre, has also launched an IP mediation certification program designed to enhance a mediator's skill in mediating IP disputes. We are also working with various law schools to include IP content in the teaching of dispute resolution modules where appropriate, including in mediation courses. Together with the National University of Singapore Law School, we recently completed a course on arbitration of IP disputes, a first such course in a law school in the world. And our experience tells us that dispute resolution options that can be customized to the dispute will often lead to optimal resolution of such disputes. In many cases, such optimal resolution translates into costs and time savings, which also thereby increases the disputing party's access to justice. Given rapid developments in today's IP landscape, it is timely for us to have a conversation about how dispute resolution options can adapt to the virtual arena on the international front today. And therefore, we are privileged to be partnering the University of Illinois, Chicago, as well as the Wipo Center for a second time to host today's webinar. In this respect, please allow me to thank Mr. Friedlander and Professor Lim for inviting IPOS to be part of this discourse, and it only leaves me now to wish everyone a very engaging and fruitful seminar. Thank you.
And now I'd like to introduce Mr. Ignacio de Castro Lamas, Director, IP Disputes and External Relations Division, Wipo Arbitration and Mediation Center.
Thank you very much, Gary. Good morning, good afternoon to all the participants. So we are delighted, of course, to be partnering in this event with the University Illinois Chicago Center for IP Information and Privacy Law, as well as IPOS, the IP Office of Singapore. We have been partnering with IPOS for a long time, since 2011. And this was for us a pioneering collaboration with an IP office. And by now, we have now established 64 collaborations with other IP offices and courts. And most recently, we have concluded a memorandum of understanding with the USPTO in relation to FRAND-related disputes in the area of standard essential patents. I will provide you some statistics about developments in the caseload and the experience of the center. And of course, my colleague, Ki Dong, will then participate in the panel discussion. I just would like to mention that our caseload has increased quite substantially in the last 2 years. In 2021, the caseload of the center increased by 45%. And this year it's increasing also very fast. So we have a 50% increase compared to last year. We have noticed that parties, as a result of the COVID pandemic, are increasingly using online case administration tools that Wipo offers. And this is further reducing the cost and time spent in some of these mediation and arbitration procedures. And it's having also the effect of even increasing the settlement rate in some of these cases. Another trend that we have seen in recent years is that originally the parties in Wipo cases came mostly from Europe and the United States. And in the last few years, we have seen a substantial increase from in the participation of parties from Asia. Parties from Asia now represent 21% of all parties in Wipo mediation and arbitration cases. And I should point out that nearly 70% of the cases that we administer are international. So these are cases involving parties domiciled in 2 different jurisdictions. In terms of the types of IP rights involved in the cases, patents continues to be the main area of disputes and also the largest disputes. Historically, we always saw disputes relating to mechanical patents or life sciences patents, but increasingly we are seeing an increase in the number of patent disputes involving standard essential patents, and many FRAND, fair, reasonable, and non-discriminatory cases are moving to Wipo mediation. And this is why we are delighted with our new collaboration with the USPTO in this regard. We also are seeing in the area of patents that cases are being referred to us, to Wipo mediation, by the courts by the IP courts in China, and this is an interesting development that we have seen in the last 2 or 3 years. In the area of copyright, we have basically nearly 24% of cases relate to copyright. We are seeing increasingly cases involving digital online content platforms and also collective management organizations. The disputes may relate to royalty disputes or setting licensing terms. But we are also seeing increasingly disputes relating to user-generated content. And of course, in Europe, this is quite topical because, as you probably know, there is a European directive on digital copyright, which encourages the use of mediation in particular. We are also following with great interest developments in the US, and we have seen that the US Copyright Commission has now introduced the Copyright Claims Board, and we are in discussions with the US Copyright Commission in this regard to see whether we can complement the existing services of the US Copyright Commission. In the area of trademarks, finally, we have a very good number of cases. Nearly 20% of cases are related to copyright. And this is an area in which we work very closely with the IP Office of Singapore, and we provide a mediation service as an alternative to the administrative proceedings related to trademark opposition offered by IPOS. And we are very pleased with the efforts of IPOS in relation to the revised enhanced mediation promotion scheme. And one of the speakers later on, Joyce Tan, has been one of the mediators appointed in some of these cases. As I mentioned, my colleague Ki Yao Dong, who is the Wipo Center's representative in Singapore at Maxwell Chambers, will present the Wipo mediation and arbitration services in a little bit more detail during the panel discussion. But for now, I would like to thank again to the co-organizers, all the efforts and all the participants for participating in this event. And from the Wipo Mediation and Arbitration Service Center, we are delighted to be here and to continue exploring the use of mediation and arbitration to facilitate the effective resolution of IP and technology disputes. So thank you very much, and I hope you have a very good seminar. Thank you.
Okay. Hello, everybody, and welcome. I join Gary and Rina and Ignacio in welcoming everybody to our second International IP Dispute Resolution seminar. And can everybody hear me? Yes, thumbs up. Okay, great. This is really, I think, an event for the time. So much of what we are dealing with is international in nature and has to be solved across national borders with all the help we can get from different countries, different organizations like Wipo. And so this forum brings together experts from all around the world to think about the issues at a high level. And so we're not going to go into a lot of detail, but what we're going to do is to focus on the dispute resolution process, on some issues across the board. And I see Alan has joined us. Welcome, Alan.
Hello.
Welcome, Stanley. And as folks are joining us, I'll just give the attendees a broad roadmap of what we're going to expect today. We're going to have a series of Q&A. Panelists can be the first to answer, and then others can weigh in. We're going to talk about international IP organizations and government IP offices as drivers of change. We're going to hear from Chiao Dong from Wipo ADR, who's just joined us. Welcome, Chiao. Stanley Lai, who is representing both Allen and Gladhill, as well as the IP Office of Singapore. Joyce from Joyce Tan from Joyce Tan and Partners. My apologies. Expert evidence and IP specialist mediators with Bill McGrath, Davis McGrath, and I should say also that Bill is the advisory board member, one of our advisory board members on the UIC IP Centers board. We're very proud of that. So welcome, Bill. Ryan Abbott from JAMS and Surrey School of Law, Health Sciences and UCLA School of Medicine. And we're going to hear also from Joyce on the Asian perspective. Study essential patents. We'll come back to Chiao. And also we have Barbara Laureate, who will be joining us, King's College and GW. And Alan also will be weighing in on that. We'll be talking about do's and don'ts in international dispute resolution, and then we're going to end with recent developments. And as Adam mentioned, please join us in the conversation. Use the Q&A feature throughout, and we'll take questions as we go along. So let's start off with the Wipo ADR services generally. And Chiao, can you tell us about what is new at Wipo ADR, what can we expect from Wipo ADR, and then I have a question from one of the comments that Ignacio made about China referring cases to Wipo ADR. So over to you, Chia.
Great, thank you, Daryl. So hi everyone, good morning, good afternoon, or good evening. So it's a great pleasure to join this interesting panel discussion. So regarding to what is new to Wipo Arbitration Mediation Center, I think maybe I can start with what is the Wipo Arbitration Mediation Center, just in case if this is a new concept to some of the audience. So as many of you may know, the World Intellectual Property Organization, so we call Wipo, is a specialized agency of the United Nations, focusing on the area of IP. So it is the global forum for IP services, policy, information, and collaboration. In general, Wipo provides multiple IP-related services, including, for example, international trademark, patent registration through its Madrid and PCT systems. But Wipo also provides ADR services to facilitate parties around the world to resolve, in particular, the IP and technology disputes. Here, for ADR services, I mainly refer to mediation, arbitration, expert determination, and domain and dispute resolution services. So these are the main services the Wipo Arbitration Mediation Service, the Wipo Arbitration Mediation Center provides. So what makes the Wipo Center a bit different from maybe other ADR institutions around the world is that so because it is a UN agency, so Wipo is internationally neutral, so it has 193 member states. So parties from different jurisdictions do not need to concern about the so-called risk of home country protections when they're resolving their cross-border disputes. And also Wipo Arbitration Mediation Center with a strong background of Wipo in IP, so it's particularly specialized in resolving IP disputes. So such expertise in IP dispute resolution can be reflected from several aspects. So for example, Wipo Center maintains a large IP expert database, including more than 2,000 experts from over 100 countries. And I'm very lucky, many of the today's panelists are also on our list. And also those experts are experienced in different areas of IP law and dispute resolutions. So parties may select mediators or arbitrators in their case from the Wipo database. So this is a very good resources where parties can make use of. And also the Wipo Center ADR rules include provisions particularly suitable for IP disputes because we consider about the special characteristics of IP disputes when we design the rules. So for example, we include provisions for specifically for confidentiality, also provisions to mention about the seizure of evidence, how to protect trade secret, how to manage the evidence for the evidence generated by experiment, etc. And also, as Ignacio has just mentioned, we have a caseload basically covering all areas of IP, patents, trademark, and copyrights. So basically, this is what is old or what is generally about the Wipo Arbitration Mediation Center. But if you want to know what is new for Wipo Center is that I think we as an international organizations, we have the opportunity to witness and also carry out researches on the latest trends and developments in IP dispute resolution at a global level. And we also able to initiate and promote some innovative practice in these areas. So for example, in quite recent years, we find that parties are more willing to use ADR not only to resolve disputes at a later stage, for example, for contractual disputes or for infringement disputes, but rather they are starting to use ADR to resolve some disputes at an early stage. So for example, when they're trying to negotiate the terms of contracts, or even they're just starting to negotiate about a new R&D project. So ADR has been using in a very flexible way to help parties to resolve differences, disputes at various stages of collaboration. So this is also a very interesting development we have seen, and we also facilitate the parties in the recent years. And also, as Ignacio just mentioned, we find that online mediation becomes a new trend since the pandemic. And this somehow helps a lot, especially relating to the settlement. So very interesting is that we see that previously the Wipo, the settlement rate of Wipo mediation cases is 70%, but in last year, the settlement rate of Wipo mediation increased to 75%. So, and most of the mediation cases were conducted online. So we don't know like whether online mediation is one of the reasons that helps the parties to reach a settlement, or maybe the other way. But we can see that the online mediation becomes a new trend for parties to conduct the mediation.
Gia, let me ask you something. Do you also think that
Of course.
because more parties are doing this online, they're more willing to bring in ADR early on in the process? Is this a change in mindset that Wipo ADR is doing a fantastic job, which I'm pretty sure you are, having now worked with Wipo ADR for 2 years, in really spreading the gospel that we should be thinking about ADR and IP dispute resolution, or is it something else? Why are people thinking of ADR early on in the process?
I think this is the way how parties are, trying to introduce a neutral to help them, because, of course, I think traditionally ADR is more for a later stage. But for parties who are very familiar with how a neutral third party, either mediators or arbitrators, can help them to resolve the disputes, or even we can say differences. So they are trying to bring the neutral third party back to the, even an early stage to help them to resolve the disputes. I think it's like a development of mindset of, from the traditional way to the new way. And it is proved that it's very effective. So I think it's a very positive circle for that.
Thanks. I want to bring Joy Stanley and Bill into the conversation at this point. If you are advising your clients at which stage you bring in ADR, what are some of the strategic or tactical considerations?
Stanley, you want to go first?
Such a gentle lady.
Thanks,
Stanley, go ahead.
Thank you. Yes.
Modern world.
Great to see everyone. Thank you very much for the kind invitation to be part of this August gathering. To answer your question, Daryl, I think a lot of it is influenced by where the litigants actually start. If, for example, they start with arbitration, and certain institutions, specifically the Singapore International Arbitration Center, may put into place ARB regime so that you start arbitration and then there is a hiatus for parties to go into mediation. And that is part of the institutional regimen of arbitration. So in that situation, you would probably be inclined to participate in that. If you go through court-based litigation, increasingly the courts are very keen for the parties to exhaust the mediation avenue. Our own professional conduct rules have also been amended so that you are expected to advise your clients on ADR options. And if you don't do so, that can carry certain consequences, including cost consequences for the client. So, and that also opens a vista for referrals to mediation institutions like the Singapore Mediation Center, Singapore International Mediation Center. Where Wipo AMC comes in, it very often is when you have a multi-jurisdictional dispute and you have opposition proceedings before IPOS, there may be an opportunity, and I have been involved in a few of these cases, where you actually use, the Wipo AMC to basically bring together cross-border parties So one party may be based in Singapore, another party may join in remotely, and we've had a few instances where you also get a good outcome. So there are many different avenues to achieve a mediated solution, but increasingly where you start is also a strategic concern, and that influences the intervention of mediation.
Thanks, Stanley. Joyce?
I think what I would add to that is that the pressure to actually attempt mediation is great, almost compulsory, I would say, in a lot of the Singapore traditional contentious proceedings before IPOS, what was referred to by Ignacio earlier in the evening, and for some of us in the morning, is that there is in fact an inability, almost an inability to carry on unless parties go back to the forum and say, yes, we have in fact attempted mediation and we have failed. So that, you know, for example, my own experience as mediator has been typically parties and disputants who come to mediate almost kicking, screaming, because they have opted to in fact voluntarily come to mediation, but were compelled through that process of almost mandatory pressure kind of thing. And what is great is that over the course of time, what I have experienced is see parties who came in very reluctantly leave very differently and suddenly believing that, oh my goodness, I'm so glad I tried this. Your question, Daryl, much earlier was, what would I do in advising clients? So it's not so much in my role as mediator, but because I'm so convinced, and I'm definitely of the camp that has seen mediation do its magic. For me, mediation is always there, lurking. Okay, and certainly there is a right moment, and sometimes the difficulty, of course, is to advise clients in a way that they believe it would be in their interest, and not because you are suddenly getting cold feet or losing confidence over the merits of their case or how things will turn out, but that, looking at it all round from a very practical perspective in terms of what it can achieve, overall, they will be having a higher probability of being winners more than if they went all the way with the uncertainty of do or die kind of an outcome. We all know what mediation offers in terms of the options. We know what it can do in a way that, traditional litigation cannot. And this is where, Daryl, if it's not too early, I can begin to talk about, a very direct use case where only mediation can achieve global settlement, literally, and truncate and obviate the need for any more litigation across 6 jurisdictions, right? We have a real case, I think Ignacio kind of alluded to it, where in the first successful cross-border what happened was that you have 2 non-Singaporean parties, one from the US, one from Thailand, mired in a very, very involved IP dispute that straddles 6 jurisdictions, no less, ongoing. And in each jurisdiction, there were multiple proceedings. And you know that if mediation did not come to the rescue, what the prognosis would have been in terms of what parties would have been involved in. They would have been involved in litigation in 6 countries, each with multiple technical different kinds of proceedings, and yet over, of course, very hard work, a very intense mediation session held in Singapore that lasted no less than 19.5 years. All 6 litigation cases were settled way beyond the scope of what first came before the IPOS proceedings. Now, which litigation option offers you that? So mediation, back to your question, Daryl, I think I would, always be there and introduce it at feel that the clients are open to it because they know that, there is no vested agenda in it. And that's kind of a long-winded
that's
sort of
helpful.
answer.
I was curious when I saw the 19.5-hour figure. And I've been told, not having been involved in these marathon negotiation processes, that sometimes parties just want to get on with things and they want to get out of the room and they want to go back to their families, and they're more willing at the 11th hour to compromise on things which they otherwise wouldn't. So was it part of the plan that you would go for 19.5 hours?
Well, I can tell you one thing. When you are the first thing you need when you decide to actually take up an appointment is to make sure that you're fit and have the stamina, you know. So I think you better be very, very well. And after that, you have to read the dynamics between the parties, whether they want to push on. And in this case, they certainly did, because people had flown into Singapore from out of. They didn't want to stay longer than they had to, and they certainly wanted to go back to their company saying, yes, I achieved settlement. So yes, Daryl, I think that's a big consideration, but sometimes it has the reverse effect. You know, when you're so tired, you could be grumpy or you know, impatient and say, you know what, I don't want to settle. I will see you in court because this is too much. It's taken far too long. So I think the mediator has to read the situation and see, do you know, like go all the way in, and that one we settled, you know, maybe 3 something in the morning, I have to say. And you know, it was reported largely as way past midnight, maybe because it's too scandalous to say you're signing an agreement at 4 in the morning, but that's what we did. You know, and at that hour, I think it's quite a delirious sense you have when you have 2 out-of-town parties who actually weathered it and stayed those 19 hours and then still had the stamina to actually draft the contract at the end. It was, you know, comprehensible enough to bind the parties legally. So I think there's no one size fits all when it comes to mediation. Could be that, could be a whole bunch of other stuff as well, but you know, it could certainly backfire.
Great, thanks. And the aftershocks example is certainly a very tangible instance of how that helps. And I'm going to come back afterwards to the question of multi-jurisdictional settlement, because there was actually, and I think still has been, controversy about that. But before that, Bill, what's the situation like in the US? You are muted. Still muted. Okay.
Good morning. Thank you, Daryl. In the U.S., in terms of timing, generally it is considered to be best to try to get the process started early on. In particular, my familiarity is with the program that is in the Northern District of Illinois Federal Court, the federal court here in Chicago. It's had a mediation program for trademark practice for over 25 years now, and I'm a mediator in that program. And part of that process is the court notifies the parties basically upon the filing of a trademark or a Lanham Act lawsuit of this program in the Northern District of Illinois. It's a voluntary mediation program. The parties can decline if they want. I think the judges exert a certain amount of mild pressure for them to engage in it. So that starts early in the process, as I said. And now the one problem you encounter in the United States, at least when you start a program early in the litigation, is that one side may take the position that, well, we can't do a mediation yet, we need some discovery. And when I'm mediating a case, one of my major points to the parties is, you know, one of the great reasons why you should have a mediation is so that you can avoid discovery. In the US, the discovery process is so expensive and time consuming, and you know, with the electronic storage of information, the electronic discovery that goes on requires consultants and experts on the electronic discovery, and so I really try to have the parties forego discovery before having a session. So that's very important in terms of the stage. This program that I'm involved in as a mediator, normally the process is I will start, the parties will enter into a mediation agreement with me. The important points of which are that the mediation is entirely confidential. Nothing can be used, nothing that's said in the mediation can be used in court or is admissible as evidence in any way. We talk about, obviously you need to decide early on whether the mediation is to be live, in person, or remote. For the last few years, of course, any mediations I've been involved in have been remote. And this was touched on a little earlier. Remote mediation, in my experience, has been successful. It does allow parties who might not be, especially in the international context, parties who might not find it worthwhile to have to travel to Singapore or wherever to engage in a mediation. It enables those parties to have a remote, and my experience has been good with it. We haven't had any sessions that went 19.5 hours, but I have had one mediation that had international components to it. And like Joyce was saying, one of the things I emphasize to parties is that the benefit of mediation is that you can create a flexible resolution, which you cannot do through litigation. Litigation tends to be binary. One party prevails, the other party loses, and that's all you get. With a mediation, you can work out a business-like solution. And in this particular case, we did have several days, 2 days at least, sessions of mediation, at which point we did come to a general settlement that did involve several jurisdictions throughout the world. And so through the mediation, they were able to resolve several oppositions and cancellations in jurisdictions outside the United States. And then in that case, as is sometimes the case with mediations, the parties come to an agreement in principle. So then they went back to finalize the agreement and put it in writing. And what sometimes happens is they came back about a month later and said, okay, we need your help again. And this time my help was focused entirely on helping them basically get around some of the hurdles that they had in drafting the final settlement agreement. And that took a couple more days, and we finally got there. That was mostly just, frankly, drawn on my experience with settlement agreements and litigation, and we just had to work out linguistic solutions to the problems that both sides were raising in terms of getting the settlement document done. So that worked well, and they finally settled everything, signed, sealed, and delivered.
Bill, let me ask you a follow-up question there. So a lot of what happens in mediation is the flexibility of parties to be able to work out terms, but also the conversations that take place in the shadow of the mediation. So these might be informal conversations, whether it's between the attorneys or between the parties, during breaks, during the course of the mediation, but not formally as part of it. Now that everything is virtual or in a virtual environment, is that lost? And if that's something that's lost, how much is lost?
Yes, obviously that is lost, and that sometimes does help the mediation process. In my experience, there isn't that much hallway conversation or crosstalk that goes on between the parties once they're into the mediation. Some parties are good and have already done that kind of crosstalk before the mediation even begins. But so again, my experience, I don't think that has been a problem from my perspective.
Okay, great, thanks. I just realized that Ryan, on top of being a professor at various places and with GEMS, also is at a law firm. So, Ryan, you want to weigh in on?
Sure. No, I
the
think
practitioner's point of view, but since you're also with GEMS, also the mediator's point of view.
sure. No, I thought we had some great input on some of the value of mediation, and I guess I could pick up a bit with, where would you start the process? And for the mediation front, I think it's really very helpful to get started early. As Bill said, discovery can be very expensive. Sometimes parties really want to see what other parties have, but it's very difficult for parties to predict how the discovery process is going to go out and how that is going to end up, making challenges with their own case. Really, almost every case is better off settling at an early stage. And as Joyce said, parties sometimes come kicking and screaming to mediation, either because courts are getting more aggressive in the US and the UK about, if not quite compelling mediation, then strongly enough suggesting it that the parties are going to go. But often parties have, for posturing and psychological reasons, told one another there's no chance the case was settled and taken unreasonable positions that don't really reflect their interest in settling the case. And getting into mediation early, starting a process, can really help to break that down in ways that are helpful to clients. It is often, as Bill said, that mediation is a long process. And sometimes I have done marathon Joyce-like sessions for mediations. I think the worst was 36 hours. Yes. I did get a couple
with bio breaks, I hope.
Well, well, now that you're online, it's a lot easier. But we are back to doing them in person also. Sometimes, for me, mediation's a long process, even if it is a one-day hearing where you start exploring things with the parties, far in advance of a mediation, exploring positions and interests and getting mediation briefs and working on the personalities involved and what may be holding up settlement or what really makes sense to parties. And so by the time you come into a mediation, a lot of the groundwork is done. And, it isn't a failure of the parties if they can't settle on the day. It is often something that evolves into a discussion and there's continued negotiations, or you sometimes come back for a second hearing for a complicated enough case. But even when there isn't a settlement, in early mediations, these things can sometimes help narrow some issues for resolution, or knock out a couple of things that the parties could have been fighting over, or at least given the parties more of a sense that a case is likely to resolve amicably rather than having to, have someone see you at trial. And while it is tempting at, 7 or 8 p.m. to say, I'll see you in court, that's going to involve a lot more time and energy from the parties. And where they're big corporates, aside from significant legal fees, the time and expense on company personnel is often understated. And particularly when we're talking about patent disputes, there's often technical people from companies who have to be involved, and it really does interfere with their ability to get their actual business done. So these costs are really quite significant on parties. When you're talking about some of the cross-border disputes that Joyce was talking about, particularly in the patent context, these cases get to be astronomically expensive and complicated, because you have different patents in different jurisdictions, which, may come from the same patent family, but may have separate sorts of claims reading on separate sorts of products. You have, motivated legal teams in however many different jurisdictions, searching Russian libraries for prior art, which, as a patent holder, you probably don't really want them out doing. There's different complex rules in each jurisdiction about all sorts of things with patent law, from, infringement to validity to even things like inventorship. And you have a significant risk that even if you do have first you have a significant risk as a patent holder that you're going to either get your patent invalidated or found to be non-infringing. But you also have a quite a reasonable likelihood that you're going to get split decisions in different jurisdictions where some of these are read as infringing and some of them aren't. So the prospect of globally settling something in a mediation, often makes a lot of sense for both patent holders and alleged infringers, and allows them both to get on with a business. And where you have mediation, and particularly in the life sciences, where you have a lot of repeat relationships and where reputations are critical, instead of getting a judgment at the end of the day that so-and-so owes so-and-so X number of dollars, you can craft, forward-looking solutions to people who need to be doing some collaborative work together, or at least who don't want to be stepping on each other's toes in a marketplace.
Thanks. You mentioned corporations, and one thing that came up last year was the surprising number of instances where you have these sophisticated companies that come in and they agree on something, and then at the end of it, they say, well, I can't really sign off on this because I don't have the authority. I need to go back. I need to talk to my CEO. The CEO might need to talk to the board, etc. And this is a question for everyone. How often do you encounter this? And are there ways that you would advise folks on this call to think about preempt and plan for it?
Well, I guess I just spoke, but I'll give a quick answer to it. This is always something I explore with the parties in advance of a mediation session. Is there someone with decision-making authority in the room? And it is always better, in my experience, to have a decision maker in the room or at least available on the day. It is the case sometimes some large corporate clients simply won't agree to that and will have to go seek authority, in which case that's made clear to the parties in advance of it. But it has usually been my experience that that's done in good faith, and the people coming, if you've explored this, even if they don't quite have decision-making authority on the day, that their consensus is respected by people who do. And it has rarely been my experience that someone has called back and said, sorry, this isn't going to work out.
For me, I make the authority of the participants in the mediation session a big deal, both before and at the start of the proceedings. So, sort of like, whether the other party sometimes doesn't even want to go on with the mediation unless they know that if they come to a conclusion, it's going to be something that everybody has the authority to sign off on. Yeah.
I think the one thing I would add to that, Daryl, what I'll also add to that is, I think the mediator's role at the initial phase, at the initial start of the mediation, is to ascertain whether the parties have authority. And sometimes in private caucus, you then get into more granularity, because very often parties have a negotiating range of numbers, and it could quite very well be that their negotiating mandate does not exceed X dollars, say, or X million dollars to conclude the dispute. So the question then is whether they would be able to secure further guidance from the management or leadership of the company to take them over the line if necessary. So you may need to also do it in two phases. One, to get the parties assuring you and each other of authority to negotiate, and then over and above that in private caucus to ascertain what perhaps are the actual limits of this authority, which can be refined and developed. But I think it's a sensitivity to that, and also to make sure that you don't let the other side know what the tolerance levels are, because private caucus by its very nature is a confidential process unless waived.
Thank you.
I guess I want to say something to this question. It's Alan Baxton. Thanks for having me, by the way, Darryl. I realize I might be the only one representing a real party in on this panel. So I think I want to say something, in my position as a party, because all companies, I think, for our successful mediators or mediations, there have been always a commercial boss in our departments, in our companies, and that the IP department, IP professionals have to be reporting to, because they are the ultimate payer or collector of patent royalties. So there's always a internal client that we have to serve, and this client do not necessarily understand the laws, understand the economics of the friend, and but they're the client. So sometimes, I think it depends on size of the dispute. If it's a large dispute, there's always an internal process that all companies have to go through in order to make big decisions, depending on the value of the case. There can be internal policies. Even the chief legal officers, general counsels may have their level of authority, and for certain amount, above their authorities, they may need to report up, and not even to always to a single person, but sometimes even to a management committee. So in such cases, I hope our owner mediators would understand that's always a process, but it doesn't mean such kind of case is hard to mediate. We've been through many mediations, countless cases. There are cases that we can handle as IP department, but there are cases that we need to call somebody during the mediation, or there are situations we need to take a few days break so that we can catch up with our management, and then we will. I think these mediators we've been working with have been flexible, and they are adaptive to the parties' internal processes. They understand these processes, and they allow the parties to go back and have their whatever internal processes, approvals, and then they will come back. So the parties, when they come to the mediation, they have a commitment. They want to do it, and they're paying the mediators, they're paying the agency to do it, and they want to get the issue resolved. So I think in such situation, I guess I hope when we say if we have to say that folks in the room may not have the authority to make the decision here, I still hope that we can be trusted, that we are not being there because we do not have a good faith. We may be in good faith, but we just have an internal process to follow. So that's my defense for the party. Thank you.
Great, thanks. I love how people are jumping in. So now that we are all warmed up, I see Ryan is also unmuted himself. But hang on, Ryan. Bill, did you have something to say?
No, I have nothing more.
Okay. All right. Ryan, go ahead.
No, I mean, briefly, the key with it is, part of the hallmark of mediation is flexibility, and, parties are often in different situations, and it may not be that a party can come to an event with mediation authority in a way that you kind of might hope they might. I think the key is being transparent about that. So if the opposing, what you don't want to happen is a tentative agreement is reached, and then the opposing party hears, you've been negotiating and you're ready to sign this, but actually they can't really agree to it. They need to go call a management committee, and they'll get back to you in 2 weeks. And that can blow a deal up, right? I mean, what you want to do is just be transparent about this from the outside, that, they say they're here to negotiate in good faith, but whatever agreement they come to, they do have to seek approval for it. And they represent that they will do their best to do so if we can come to an agreement today. And then it's not a surprise deal destroying disclosure at the end of something. So I think transparency and flexibility for this is key.
Okay, great. I see Barbara is here. Barbara, what do you think of arbitration and mediation?
Well, as far as that, I know the conversation's really been about mediation, which I have some limited experience with representing parties. And I was just thinking, listening to everyone else's comments about mediation, that how important it is to select a good mediator, because when I've seen really effective mediators that work, they're very forceful. I mean, more forceful than you might think, given kind of public perceptions of mediation. But I've seen mediators really bully some pretty resistant parties into making sure that those decision makers were actually in the room when they didn't want to be, and keeping things going when parties were willing to walk away. So I think so much of this comes down to really the selection of a mediator who's able to manage these things, and to get the parties to kind of bring them along with them.
Thanks. Now, I noticed that you made a clear distinction between mediation and arbitration. Of course, the two are different, and you just spoke about mediation. What is your view on arbitration?
Well, I mean, I remember when I sort of first started working in this area in the early 2000s, the very first lesson I learned from an experienced arbitrator was mediation and arbitration are completely different things. We lump them into alternative dispute resolution, but really they're completely different. The mediation being, I mean, they're both voluntary, and they both result in some kind of resolution of the dispute, but arbitration as a process that is really where the tribunal issues an award that is the end, versus mediation where it's a guiding them to settlement. They're just completely different things. Now, one area that I think I've seen, and this is a sort of positive development in the area of IP, is not seeing them as alternatives to each other. So even though they're very different, I think that we see this at the Wipo Center, encouraging parties to start with mediation and then enter into an agreement to perhaps a submission agreement if they reach a certain stage without a settlement. So there's absolutely no reason why they can't work hand in hand.
So a follow-up question for you, Barbara, is with respect to FRAND. So you've been researching and speaking on how arbitration is a bad idea. Repeated arbitration is a bad idea for FRAND. Tell us a little bit about why you think so and whether your views are different when it comes to repeated mediation.
Sure. And of course that my comments in FRAND are partly because to be provocative, because I think that we've seen a huge amount of momentum pushing towards settling the global FRAND disputes using international arbitration. And I completely understand the attractions of it. And in a way, it may well be the answer to this problem that is increasingly dominant in resolving FRAND disputes. But there are these unintended consequences that I think that many people are ignoring. So what do I mean by these unintended consequences? Well, we have to remember, I think, that FRAND itself was meant as a solution to a problem. So the problem being that if we think about as sort of IP, I come from the academic perspective, we think about IP as incentives, as an attempt to kind of balance different rights, public and private. It's a very delicate balance, and we have to think about where the incentives are. With standard essential patents, it's almost this double charge monopoly. And so that creates this potential problem, potential antitrust competition issue that has to be. FRAND becomes the voluntary FRAND commitment, the solution to the initial problem of how do we manage these markets where you have the standard essential patent holder in a position of perhaps too much power, too many opportunities to abuse that position. Now, of course, as many the patents SEP holders would say, the balance has shifted too far to the other side because of the FRAND commitment and the limited ability to obtain injunctive relief. The balance is now shifted, they think, to the the implementers. Now that may well be true. Of course, one of the problems is that if we have patents are national, these agreements are frequently global, and so international commercial arbitration right there has this big attraction of thinking, well, we can resolve everything, well, just as a mediation would, a successful mediation. But here is where I do think there's a big difference, because a successful mediation is really an extension of the negotiation process. And setting FRAND is meant to actually mimic a sort of natural negotiation process, fair, reasonable, and non-discriminatory. The resulting contract on FRAND terms is supposed to be what the two parties would come up with, in a sense, a kind of arm's length negotiation without any abuse of power by the SEP holder. So in that sense, it's very different from having a court or a tribunal actually making a determination. Now, sorry, that's kind of a lot of preamble to get to the point of why I think that we have to be a bit careful in the area of arbitration, is because confidentiality is such a big part of the culture of arbitration. Now, of course, as many will say, well, they don't have to keep things confidential, but the fact is we don't know how many FRAND arbitrations are happening. We don't know how many, because they can exist. So the public doesn't necessarily have the information. The parties don't necessarily have the information. Any kind of decision, even which kind of choose to determine royalty rate, comparables are relevant. So comparables are relevant. They're going to want to have these other access to other licensing agreements, to be awards in our proceedings, so that they can have this information to actually come to a determination of what is FRAND in a particular case. So the more arbitration that confidentially, the less information is publicly available. And of course, third parties are involved as well. So that, a party can say, well, this is a third party license, it's confidential, we can't share it with the tribunal, and the tribunal has limited powers to compel them to show that. So one of my fears is that while we solve potentially one problem of how to determine these rates globally and have a decision maker that can determine these globally, then all of a sudden the information becomes used between the parties for gamesmanship. So it's all about using the more information in a potentially competitive. So I think that's one of the things we have to be careful with. There also, there's this kind of, on the one hand, a lot of the arbitrating FRAND disputes will say, well, the parties do not have to keep it confidential, but of course, there's a lot of, well, I want you to show me yours, but I don't want to show you mine. So I think the confidentiality issue is a big one. So I'll just stop there for now and throw it out to others to comment on that.
Okay. Who wants to take Joyce up, Barbara up on invitation to comment? Stanley?
Yeah, thanks. Yeah, great comments, Barbara. I share your view in relation to confidentiality. I think the other concern also is subject matter arbitrability. I think for the longest time, certainly in Singapore, the pressure that was brought to bear on practitioners was whether you could actually arbitrate the validity of a patent that was cited from another jurisdiction. And of course, the danger, having got the award, is whether the litigants can take that and enforce that award in the country of registration. To a certain extent, that's been ameliorated because now the Arbitration Act and also the International Arbitration Act in Singapore has been amended to allow the parties to agree for these findings of validity or invalidity, to bind them in personam. And regardless of what the register in question says, that's how the parties will approach that particular finding. So that's another hurdle I would have thought that was often quite a big obstacle in getting parties to come together in arbitration to resolve this this validity, particularly of a foreign patent, because you won't have that similar experience in court. I mean, most a lot of courts will not entertain, of course, jurisdiction to try the validity of a patent that is registered from another jurisdiction. So that I think would be something, but I think to a certain extent, I think legislation has helped solve that. And in certain other jurisdictions, it's actually hard coded into legislation that you can resolve the validity of a patent by arbitration, because it's very often the case in a patent infringement proceeding that the respondent or the defendant will respond either with a plea of invalidity as a defense to patent infringement, or as part, or may raise a counterclaim to revoke the patent in any event to what he does in his defense. And so it's a very much a live issue. Some traditional mediator, arbitrators have basically said, well, I desist from trying validity. I'll just try infringement. And it's always a difficult task to persuade parties to go down that road, because at least one of the parties would want to canvass the issue of validity pretty early on. That's my comment, Daryl. Thank you.
Daryl, I know I'm supposed to be answering questions, but do you mind if I ask Barbara a question?
Oh, please go ahead.
Barbara, I really enjoyed your comments very much, because I think this whole privacy of arbitration proceedings and all that, in some ways, sometimes strikes me as being kind of like, unsuitable to SEP disputes. And I wanted to ask you whether you believe, given the concerns about confidentiality and the need to address the non-discriminatory factor with SEP licensing and all that, that actually arbitration of SEP disputes favors the SEP owner in some way, more than, let's say, the licensing community in general, who need access to the information you speak about.
Yeah, that's a very interesting question. And of course, I'm not sure there is a straightforward answer to that, in that, of course, there's a lot of cross-licensing as well. So it isn't as clear-cut as kind of SCP holder and implementer. But I suppose the easier way to see it is that it definitely does advantage established companies over any new entrants to the market. So I think that it's definitely something that already has had some attention from the kind of competition antitrust area. And usually it's when I got into this, I think there is this sort of sense of, well, of course, IP lawyers and antitrust competition lawyers don't really see eye to eye on lots of things. But I looked at this, the more I thought, actually, the competition lawyers really could have a point here, because the information is so important to the calculations. And going back to the point about arbitrability of the subject matter, yes, one of the usual, yes, there are ways to get around this, but one of the usual ways to get around this is to kind of make some broader determination that where somehow validity or invalidity is taken into account when assessing the value of the portfolio. Of course, it's still making some kind of judgment on validity or invalidity, but it's kind of dancing around the issue. But is that given that this whole kind of trend idea was a solution to this problem, is kind of increasingly less accurate calculations for brand royalties due to the confidentiality and lack of information, and potentially these this avoidance of determining whether these patents are valid or not, so that they might be sort of largely valid for one license, but not for another. I just think we're going to get increasingly inaccurate brand royalties. So yes, it's a problem.
Thanks. Joyce, does that answer your question?
Yeah, I mean, it just makes me more assured of the concern, if you like. I mean, it's a problem because you know, when we get into SEP, one of the contentious steps is that some of these SEP owners, you know, sort of say, I want an NDA before I negotiate friend terms. And that itself is where the challenge lies, because which is what Barbara's talking about, you know, about is it really being faithful to friend principle? Say in the first place, I want to have an NDA before I even negotiate friend terms, you know. And I think it's the same with arbitration when you get into a dispute over that. So thank you for appreciate it very much.
Thanks, Joyce. Kelly.
Yeah, I just want to, you know, and thanks very much for your comments, both Joyce and Barbara. The one thing I would also say is that, you know, I mean, if it came to negotiating a friend stroke SEP kind of dispute, I think arbitration, to me, if it's managed well, allows you to approach it with greater granularity. What scares me about friend decisions is if you go before a certain national court and that judge or the relevant court feels that they can set friend rates for the whole world or for a large region, and that's when that process completely runs away from the SEP owner's ability to manage his licensing strategy. So I think that's the one danger which I think arbitration does to a certain extent help with that, because I think a certain amount of secrecy and determination under that, and you can apply waivers after the award is made. You don't have that luxury with court proceedings that can you know, be quite far-reaching and certainly deviate from the initial plan. And the other comment I will make is that I think with SEP litigation, like any type of patent litigation, the underlying assumption must be that your patent has to stand up to scrutiny. I think if you have a situation where the SEP patent itself is vulnerable to a challenge or invalidity, then I would posit that you know, I think that needs to be repaired first before you undertake any act of enforcement. Otherwise, it will be very nebulous to inject that into the valuation process as a factor of consideration.
Thanks, Debbie. Chia?
Yes, I also want to follow up with Dennis' opinion, so trying to bring another perspective, friend arbitration, for example. So actually, we think, of course, there's some concerns about friend arbitration, but on the other hand, we have to understand that, or remember that arbitration is a consensual procedures. So actually, parties have a great autonomy throughout the process. So for example, they can choose the arbitrator they trust with, and also they can choose the law. So they have many like freedom to decide or shape the procedure they can go through. And also, for example, in our Wipo arbitrations, especially for friend disputes, so we would guide the parties to, you know, when they're signing the submission agreement, we would suggest them to make it very clear in the submission agreement about the authority, or you can say the jurisdictions of the tribunal. So for example, whether the tribunal has the jurisdictions to decide on the validity of the patents, or whether the patent is SEP, or only on the royalty rates. So actually parties have many ways to trying to shape the disputes resolution process in a way that they prefer, and they have more freedom as compared to when they're doing litigation. And also one thing I want to mention about confidentiality. Of course, on the one hand, I completely agree with Joyce and Barbara about, you know, about the concern. But also on the other hand, we find that in real cases, especially in the mediation, it is because of the confidential environment that parties are willing to share more information than they do in like a public court litigation or something. So for example, during mediations, especially during the caucus mediation meeting, the parties are very willing to share the comparable license to the mediator, to helping them to narrowing the gap between the proposed licensing agreements. So I think something is like a two-sided arrow sometimes. Yeah.
Thank you. That's helpful. I want to bring Ellen into the conversation, because Ellen's company not only represents stakeholders as an SEP holder, Huawei owns standard essential patents, but also licenses them. And in this new world, we also see that Huawei is pursuing other licensing models too. So Alan, come into the conversation. Tell us what is Huawei's thinking on the SEP licensing process. I know that you also wanted to make some comments about the overlooked benefits of negotiation. Are you there, Alan? Okay, well, we're waiting for Alan to come back. Stanley, I want to follow up with you on a point that you have made earlier. Brian, you muted yourself. Did you want to say something?
Oh, well, while we're waiting for Alan to unfreeze, I was just going to briefly follow up on you were asking about the benefits of arbitration, and you know, Barbara was talking about it in the SEP context, including the confidentiality bit. The confidentiality bit is often critically important to parties to this. Particularly in the life sciences, there are often kind of very sensitive commercial matters and trade secrets being discussed, and so decreasing the likelihood of a deliberate or inadvertent disclosure of that in litigation can be a big bonus for people participating in this process. So that is often kind of, for some clients, a key determinant for doing this in the first place. And if one has an arbitrator who is, able to maintain control over the process, it's almost always significantly faster and less expensive, because we don't have, especially now, COVID court backlogs, and because discovery and arbitration, at least compared to U.S. standards, is significantly streamlined under pretty much all of the institutional rules. But it looks like Alan's back.
Yeah, I'm back. Can I be heard?
Yes.
Oh, great. Sorry, I had some problem. I heard the question though. I think before I talk about negotiation, I have a little bit of comment on arbitration. I think the arbitration itself is not the thing to blame if we have a problem with the privacy and confidentiality. It is the party. It's not the arbitration who's not openly allowing access to their agreements. There might be good reason for it, but I think in terms there's a arbitration, it doesn't really mean the result has to be confidential. Even as a result of negotiations, parties can agree to agreement that allow a third party to have certain access to the agreement. Sometimes we would make such request, such suggestion to our licensing counterparts, asking them whether they would be okay for us, Huawei, as one party of the agreement, to show the agreement to a third party when we negotiate a separate license with that third party. And we have experiences, mixed experiences. Some of our counterparts have been more open, so we had such kind of agreements. But still, many other parties are not as open. Sometimes they are very secretive, and they want not just the terms and conditions, but even the existence of the agreements to be confidential. So it's not I guess the arbitration proceeding, the process itself to blame. It is the parties that, for whatever reason, maybe they have good reasons, but unfortunately, many of these licenses are not public or not well, in the case, they can be allowed to be accessed by the third parties, but they don't have to be fully accessible. So they don't have really to be public, but just in some form to be accessible by third parties. That will increase the transparency of FRA negotiations. So that'll be my short comment to that. But I think I do want to talk a little bit about negotiation, because I'm a big believer of it. Before I come to the IP area, I had some experience in on the commercial side, working marketing departments and dealing with agreements there. So I think in terms of negotiation, there's always more flexibility, because when two parties, two sides have the good faith, have the intention to close the deal, to resolve the issue, they would come up with more flexible business considerations. And there can be, for example, in terms of friend licensing, unfortunately, the royalty rate may not be as flexible, but there can be ways to discuss existing licenses. There can be, if the parties have the desire to conclude, there can be ways to address issues of the royalty base. We had been flexible. Even Huawei recently, we had been trying to adopt a license strategy we call license to all, so that we make our licenses available to not just the end user product, but also to intermediate products, chip level, module level, and so that will give flexibility to the royalty base. And also we can be, we can introduce other technical aspects to the agreements. There can be technology licensing combined. In addition to patent license, we can provide our licensees technologies to help them, not just allowing them to use the patent, but really help them to use the patented technologies. So that can bring some value to the licensees. So I think there are endless maneuvers parties can do when they come into a negotiation. I guess such kind of business considerations could be sometimes hard to be managed through arbitration or mediation processes, but negotiation can give the parties more flexibility. But that doesn't mean arbitration and mediation has no value. We've been through a handful arbitrations, and when the stakes are high, and the parties all have good faith, but somehow they just cannot resolve the issue, and they would arbitrate. And there have been many benefits to arbitrate if again the stake is high, so maybe the arbitration worth the effort. Mediation is more lightweight. Again, we had many more mediations, and in particular, when we talk about a friend dispute, if in the mediation process we can have some way to have the mediator get more access, better access to comparable licenses of the parties, then this mediator will be much more powerful in terms of resolving the dispute. If a mediator is highly credible and has a high reputation, I think it will be easier for the parties to get third-party agreements to share the comparable licenses with the mediator, so that the mediator will have better ideas and equipped with law, and they will be very convincing. They can be much more convincing than just the parties explaining their existing licenses and talk about their businesses, because the mediator may have the ability to look into the confidential information that the parties, for whatever reason, cannot share directly to the other party. So we do feel like the mediation, is in situations where there is a confidential problem, really can help. Of course, depending on the availability of comparable licenses, but definitely it provides an alternate route for the parties to resolve the transparency issue of friend negotiation.
Thanks. That's a very helpful corporate insight, which we don't often hear. I see that we've got questions from the audience. I'm going to get to those momentarily, but just a quick follow-up question to your point, Stanley, about how we have national tribunals, courts who are deciding global friend rates. We have been talking about ADR at a individual level, at a party level. Do we also now need to think about ADR at a national level between governments so that we have a code of conduct, if you like, for resolving these types of issues?
I completely agree that that's the next phase, because I mean the one thing we didn't mention in the mediation discussion this evening is the Singapore Mediation Convention, and to me that convention when it was executed a few years ago made a certain breakthrough, because for the first time, I mean there is now the possibility of multi-jurisdictional recognition and enforcement of mediated settlement agreements, which I think helps the enforcement and the enforceability of friend settlements, for example. And so I think a natural progression from that would be to have more G2G and government-to-government protocols set up to evaluate what actually should be an appropriate friend rate, or at least considerations that should be applied universally. I think I would be more comfortable with a process like that than perhaps for a judge that may want to overreach and be a bit too broad in its coverage, and without any regard for the fact that it may actually have a lot at stake for the licensing party or even the licensees. So I completely agree with you, but I think agreements like the Mediation Convention has gone some way to bring mediation almost up to the same level as the New York Convention when it comes to the enforceability of arbitral awards.
And what would be the most effective vehicle for that? Would it be through Wipo, for example, like the bilateral agreement that USPTO and Whiteboard has signed, and then you use that as a nucleus and grow it? Would it be through free trade agreements, and then you tie it through trade, and you have the RCP or you have the CPTPP or something else?
I mean, my own personal view is that I think Whiteboard has a great track record in managing friend disputes and friend settlements. So I think that's where the conversation should start. Obviously, IPOS would like to be part of that. And with this ramping up, because I always look at Wipo AMC as a bespoke IP dispute resolution center. And if other centers and other institutions catch on to this modus of settling or resolving such disputes, then well and good. But I think as a lead agency, it is uniquely placed to take a role in this. Yeah.
Thanks. Before I go to the first question I see, which has 5 votes, I want to invite TL to weigh in, since Stanley has referred to your outfit as bespoke, and to also ask you whether you have any comments on the USPTO WIPO agreement on SCPs.
Yes, thank you. Yeah, so maybe first some general background about the MOU we signed with USPTO very recently. So in the just past July, USPTO and WIPO signed an MOU agreeing to undertake joint efforts to facilitate the resolution of disputes related to SCP. So based on this collaboration, both entities will collaborate in promoting the use of ADR to resolve SCP-related disputes in the United States. So this is a very, very good starting point where we want to collaborate with USPTO, actually, as well as all the states and on the world to facilitate dispute solutions in this area. We have received around 60 friend mediations in recent 2 years. We find a special area, and we are very interested in looking into it. It has very special characteristics, and also how parties would react in this type of mediation. So definitely, we would be happy to provide better facilitations. tailored services, tailored submission agreements. We also provide a guidance specifically for friend dispute resolution. So we want to try our best to following the latest policy, the latest development in this area, and also to trying to best suit the needs of the parties in facing this type of disputes around the world.
Thanks. Just out of curiosity, why did you pick 5 years as the length of the agreement? And what do you hope to
5
achieve after
years.
that?
Of course, I think there is no limitation for collaboration. That is for sure forever. But 5 years is definitely a not too short or not too long term for trying to review and refine the collaboration. I think for the first 5 years, this is definitely a very, very good starting point, and we can work along and to see how to refine the collaboration after 5 years. Maybe there's some new policies, new practices in this area. So I'm quite positive for the next 5 years and next 5 years.
Okay, good, thanks. I'm sure the USPT will be happy to hear that too. So going to the question from the audience, which now has 5 votes. Question is the ADR process only for disputing parties and their lawyers? How do IP officers get involved? I think this is a great segue to invite Stanley to talk about IP process initiatives in getting IP officers involved in the dispute resolution process. And then after that, I'll open it up to other folks to weigh in. Stanley?
Thanks, Daryl. I think this is where I would just make a brief reference to Singapore's IP strategy 2030, which really is a national strategy that supports enterprises and the wider innovation community, including one of the arcs would be dispute resolution. And one of the things which it also seeks to do is also launch professional development initiatives such as the young IP mediators. You know, the idea that you need an IP office to champion the next echelon of mediators, hopefully from a younger generation of professional. And IPOS also has started a revised enhanced mediation promotion scheme, REMPS. In Singapore, we like our acronyms, so I apologize to the audience in advance. But the REMS is actually a funding scheme by IPOS to cover part of the parties' mediation costs, and up to 80% of the mediation-related lawyer or agent fees can be put up as part of this scheme. And the whole idea is to encourage parties in IPOS proceedings to choose mediation by funding the process so that they can experience mediation. And it's one of these entry-level steps that hopefully would encourage parties to look beyond to other dispute resolution fora and also develop the process. And of course, there are conditions as well. I mean, one of the conditions of this scheme, it's subsidized, but one of the conditions would be that a young IP mediator professional is identified and allowed by the parties to sit in and observe the process. And so much of this comes by experience and actually on-the-job training. So I think, it's one of these steps which I think can gain some traction, and certainly in developing cognizance for areas like friend disputes, it will build this. So this is one example of, I think, an initiative by a national IP office, which I think can carry some traction. But I'm very happy to learn from the experience of other jurisdictions as well.
Like other jurisdictions, China.
Can I jump in just about
yes.
So there is, just thinking about the agreement between Wipo and the PTO. Of course, in 1983, when the Patent Act was amended to allow for arbitration of patent disputes, a reporting requirement was included. So in Section 294 in the U.S. Patent Act, the awards resulting from any arbitrations involving US patents is actually supposed to be reported to the PTO, to the director of the PTO. Now, I've asked former directors of the PTO in the past about this, and they've never even heard of this provision. And I don't know how many of you are aware that there is, in fact, a reporting requirement where awards involving US patents are meant to be brought to the notice of the PTO, and if that's kind of coming into the collaborative work between a question is this something that people are aware of? And then the other point is that, of course, this is actually hardly ever followed because it's fairly easy to avoid.
Thanks. Right, Bill?
Certainly aware of it, and I think, as Barbara said, the operative word is should. In practice, parties may or may not end up reporting it, particularly if an award, it does not need to be enforced by a party. They have less incentive to do it. But this is something that sophisticated parties arbitrating patentable issues are definitely alive to. And one of the reasons why these why arbitration may settle prior to a final award is to, avoid having to report an award like this.
Thanks. Bill?
Yes, Daryl. A quick comment in terms of intellectual property offices getting involved in alternative dispute resolution. It's the Copyright Office in the United States. This is not exactly arbitration or mediation, but it's an interesting new development. In June, they launched what's called the Copyright Claims Board. It's a small case forum, so to speak, where parties with smaller disputes, copyright disputes, a plaintiff can file a claim in the small claims court of the Copyright Office. It's an entirely voluntary proceeding. That is to say, the respondent can opt out and say, no, I don't want to do this, sue me in court. But it's a nice alternative for smaller claims where the parties are in agreement, similar to, say, a mediation or an arbitration where the parties actually consent to presenting their case to this claims board. And it's a much less expensive, the filing fees are less expensive than federal court. The process is much more streamlined. There's very little, if any, discovery. Minor discovery is allowed. And there's a cap on the amount in controversy. The maximum that can be awarded is $30,000. So, but it's a nice solution for small cases that really economically don't warrant being in federal court. So it's an interesting new development. My initial thought was, well, what defendant or respondent would agree to that? But I've heard the initial reports, and this just launched in June, but that the response rate is pretty good, that respondents are agreeing to proceed in this manner. And all the proceedings are basically remote or done on paper. So it's an interesting process. We'll see how it works out.
Thanks. I have a quick follow-up question for Stanley on the subsidies that foreign parties receive if they want to embark in this thing. And then we can take another question from the audience. So Stanley, so taxpayers are paying for these subsidies when parties decide they want to use Singapore as an ADR location. You talked about how part of it is this obligation to train young mediators. Are there other things which the Singapore government is thinking about in saying, well, these are really private disputes and taxpayers shouldn't be subsidizing private dispute resolution?
I think that the REMPS is part of the SIP study strategy, and it is only confined to IPOS proceedings. So we're not talking about a cost bracket that is ultra exorbitant. The funding covers fees charged by the mediation service provider, the mediator's fees, and also, as I said, up to 80% of the lawyer or agent fees, agency fees that are involved. And I think that is one way to try and incentivize the use of mediation at the early stage, particularly with the younger professionals. Across that, even in court, I mean, one of the things that we've started in Singapore is a fast-track IP litigation system that mimics the enterprise court of the UK, where you can try and get a quick and expedited hearing of an IP dispute within 6 months or so. There's always a limit to how much you can recover in damages, but the full suite of injunctive remedies are available. And this is also another way where hopefully parties, and particularly SMEs, will also be able to see their rights enforced through a relatively inexpensive process compared to a full-blown, high court dispute resolution kind of track, which can go from 1.5 to 2 years from the time of writ filing and service. So I think that, and in some cases, as it has been found in the UK, because I was part of a committee that studied these IPAC cases in England and observed that with many SMEs, they could find it quite useful to know that within 6 months, with very active case management by the judge, you could expect a judgment within a certain time frame, for which there is no deviation. And that can mean the difference between securing a bank loan or not, you see. So it's another initiative which I think will also help the ecosystem pursue swift and efficient dispute resolution. Yeah.
Thanks. I think this is a good point to transition. To use this next question from Keith to transition into the do's and don'ts of ADR. This question is, given how important confidentiality is to mediation, from your experience, what are practical ways in which confidentiality can be maintained in an online mediation setting? This is a question to the panel, so feel free to answer.
I'll have a go at that, Daryl, but before I do so, I thought I'd just supplement Stanley's sharing about the REMPS scheme, that while it covers disputes arising out of IPOS, if the mediation includes an overseas dispute, the funding actually gets enhanced. So under the current scheme, I think they cover 1,000 for the dispute, but if you include a foreign IP dispute, it goes up to 14,000. And on your point about taxpayers' money, it is a fixed pot, so when the pot exhausts, it's going to be over, the funding is going to end. And I think at this point it's 180,000, so it's a fixed amount.
So we should say at this point that the audience, you have first dips because you have early notice. It's a fixed pot. So
yeah, and really for those,
you get
for the audience out there, if you have a Singapore IPOS dispute and you got, sort of the same type of the aftershocks case. In fact, that's what happened to the aftershocks disputants. They got the enhanced funding because they had more than an IPOS dispute, which is actually the way, going back to the very first question that was asked about, is ADR of IP disputes only for disputants and their lawyers? How do the IP actually, the dispute could arise out of a proceeding within that IP office, and the rest is what the IP office does to promote ADR. Now I'll come to the question. The online phenomenon in terms of online mediation, and we've had a lot of experience on that in a real-time practical basis over the past 2 years because of the COVID and all of that. I thought it was a very interesting situation because who ended up having to hold online mediation. I found myself having to develop a new set of protocols and protocols which required a different set of discipline. So for example, if we were in a physical setting, we would know that, okay, who's in the room is in the room. There would be authorized people participating in the mediation. But in an online, we were in different locations. I developed a protocol where I made the parties giving me an undertaking, and I tended to do that beforehand, that they would be responsible for ensuring that they wouldn't let unauthorized parties come into the room. And if somebody accidentally sort of like, invaded the room or got into the room they shouldn't have been, that the parties to the dispute would basically notify me, the mediator, and that we would immediately suspend the proceedings until we rehabilitated the situation where that confidentiality was assured, and many other types of decisions. So for example, we were very heavily reliant on technology as we are in this session. And one of the things that happened is that when we caucus sessions with a party on private terms, you don't want the other party suddenly being able to have access to come into the room, which you believe you were having a private session with one of the parties. So having to do was to be very technologically adept, to make sure that I was controlling the room well and not admitting the wrong party when I thought I was speaking to the other party. Then I developed another protocol to not let parties actually share screens. I said, please make sure you have your own computer, and if you're sharing no more than 2, and that kind of thing. So we had a lot more logistical, precautionary measures to take just to be faithful to maintaining this confidentiality that is in the question. So I think that's what happened in an online. It's a very good question because it appreciates that the practicalities of handling this in an online situation is totally different, and the assumptions you make have to be undone and in fact, questioned quite fundamentally. So I hope
I think TL and Ellen are both unmuted as well. TL.
Okay, thank you. Yes, indeed. So for online mediation, as Joyce just mentioned, we have seen many new protocols. Some are introduced by the mediator, and some are introduced by us as the center who manage the cases. So what we do is the Wipo Center has provided a checklist to facilitate parties to conduct mediation online. So we include some details for parties to think about when they are deciding or thinking about doing mediation online. So of course, usually before the mediations, parties are to ensure that confidentiality, they may think about signing some confidential undertaking as what they do in normal in-person mediation meetings. But after that, I think one important thing the parties may need to decide is to use which platform. So what the Wipo Center can do is we can provide some platform, for example, Zooms or WebEx, to help parties, of course it's at no cost, to help parties to conduct mediation online. And one problem, as Joyce said, so for example, when parties want to caucus meetings, so we are glad to see that most of the platforms now, they have developed the technology, for example, the breakout rooms. So what we need to do is we just need to facilitate the mediators, of course, upon agreement of the parties to help them to make sure the procedure is going smoothly and in a confidential way. So we as the institution, and we are in a neutral position to provide a platform where parties can be confident of the confidentiality. I think that is something we can do for the parties. And
but Chia, I can say, yep. Wipo does a great job at that. That support on WebEx is fantastic. I've used it, and it's been really great. And your technology team is also been very great.
When you ask for your budget for next year, you should include as an attachment a recording of this event where
I will for sure.
Saying that your outfit is bespoke and you've got a user there saying that it's fantastic, and then ask for 30% and profit share.
I will. Thank you for the good suggestion.
Ellen, any comments?
Yeah, I guess there are whole lots of confidential meetings each business must be having, in the past 2-3 years. We as a big company, we have a lot of internal meetings being confidential, but we use online systems. So I think technically there shouldn't be any problem. To be honest, I don't have any experience in mediation settings or arbitration or court hearings that I have seen a different requirement than what we typically have in our routine business. But there is something maybe a little bit tricky when there are many attorneys sign only documents that you don't want to, the attorneys have to be very careful in not even sharing those with their clients. But other than that, I don't see any special requirements. But I guess I want to take this chance to counter what Dr. Lai said about the speedy trial in Singapore. I think that's something very, very interesting that would be very helpful in promoting the IP protection, because patent litigations and arbitrations and mediations all take a lot of resources, and if you cannot resolve disputes quickly, for a patent owner, let's say you have your patents in the French setting in standards are typically used by at least dozens of users, implementers. If you want to go over, resolve these disputes with them one by one, it will take forever if the legal proceedings are taking too much time. So I think have high compliments on IPOS efforts in shortening the legal proceedings time.
Great, thanks. Did you want to respond, Stanley?
Yeah, thanks very much, Alan, for that comment. The only caveat I would raise also with patent litigation, and we're encountering a few cases like that. It really depends on the patent in dispute, because if there is going to be extended fight over validity, and you envisage a lot of expert evidence and also science and prior arts, then it may be better to use the normal track, because the danger of the fast track, it helps and is very useful for straightforward cases, but if you it succeeds because the judge is able to say, look, I'm just going to, your parties want me to deal with 6 issues, I'm cutting it to 3, and I want expert evidence led on each point, but not exceeding half a day. And so over 2 days, the trial is over. So some parties may feel, well, that's not enough time for me to even lecture the parties on the common general knowledge of the state of the art, much less deal with substantive points. So I think I think an analysis needs to occur between the lawyer and the client as to what is the best means forward. But if you can establish a certain comfort level in using the fast track, then injunctive remedies are available as well, and that's helpful for licensing strategy too. I'll just make that point.
Yeah, Dr. Lai, I think this is I think this could be very important for we've talked a lot about standard essential patents today. One characteristic of standard essential patent is all infringements are the same, all validities are the same, because you are basically dealing with the same standard, same patent, and maybe it's necessary for you to go through the full proceeding once, but after that, then it will be easier to go through this speedy trial and still get a quick result. And I think that will be very, very helpful.
Yeah, that's the voice of an experienced patent licensor. So thank you.
Joyce, you're unmuted. Did you have a comment? No. Okay. Actually, this is a good point to bring Joyce and Ryan and Alan in. One of the things we talked about during our planning call was the use of technology in dispute resolution, including artificial intelligence. What should folks on this call know about the use of technology beyond Zoom, beyond web-based platforms for video conferencing?
I'm happy to kick it off. I think when we look at technology in the first point of differentiation that is probably useful to be mindful of is the question of whether we're using technology as a means of communication to facilitate it. Zoom, the automation in filing, the audit trail read of procedures, video calls, asynchronous chats, and whatever not. And all of that basically really facilitates communication, which is key in all dispute resolution proceedings, of course. But I think what's on the cutting edge now, which we kind of got into as well, but we don't see it sort of like widely adopted. But really, I think the sneak view into the future might be whether there will come a time when certain types of dispute might be aided in its resolution through the use of technology, not just as a means of communication, but as the actual dispute resolution solution itself, where you start using, let's say, smart contracts, artificial intelligence, where the outcome of this technology basically the solution to the dispute. And I don't know whether it's a pipe dream and what the dependencies are for that to happen, because then you'll have to be able to essentialize the nature of the dispute. And maybe some are more suited to it than not. Let's say, for example, pure claims of a financial, such as the sort that Singapore recently launched for telecommunication and media industry. Not that they use technology to resolve the dispute, but really it is a scheme where the regulator in the field implemented a mandatory dispute resolution proceedings where the licensees of the service providers, the licensed service providers, were compelled to submit to dispute resolution scheme that was aided by technology, right? So, for example, where you have subscribers to telecommunication services, usually of service provision problems or non-payment of subscription fees. Very, very simple disputes that are voluminous in terms of the frequency and the number of disputes that arise. So you need to really clear many of this kind of smaller disputes under a mandatory scheme that is tied to the licensing of the service providers. And that is enabled because of the deployment of technology in terms of its use as a communication channel. So that's one. And again, I wanted to just appreciate the distinction between the futuristic view of using technology to actually resolve the dispute. And I'm getting feedback, right? Technology.
I think there's a fire on Daryl's side, but he's bravely just muting himself and not fleeing the building. So this is good.
I see. Okay.
Captain will go down with it. Brian, go ahead.
Excuse me. No, I thought those were some great comments from Joyce. Of course, we are all living now in the age of online dispute resolution, where kicking and screaming the legal system was dragged online and discovered to its surprise that just about anything we were doing in person could be done online, although the dynamics change in all sorts of subtle ways. Even for this event, it is so much easier with all of us in different parts of the world to just call in for a couple hours versus all going to Chicago. But it does change the dynamic of being there in person and getting to meet people and forming that rapport in, people getting to network. Not that Remo isn't great, but, drinking and networking, which always helps with the networking, and for mediations, it, is a different series of dynamics, having lunch all in a room, having a joint caucus in a room together, or being on a Zoom room together. And it takes some different skill sets to optimize that. And sometimes it could be more effective, and sometimes, it can be a bit of a challenge. And similarly with arbitration hearings, although, the penultimate hearing is often in person still, the dynamics of it change. In terms of having AI assist with this, some of it is a pipe dream, but some of it is here right now, you know, particularly for low value, high volume sorts of disputes, the sort of thing where if you were hiring anyone in this room to do it, it would eclipse the cost of the amount being fought over. There's a lot of room to have AI potentially even automate aspects of the dispute process. And eBay was the first online dispute resolution system that, you know, significantly relied on AI. Not only so, if you have a dispute on eBay, it first goes through an automatic process before a person is involved. And when they did that, you know, not only did they cut an eBay neutral out of the process, but settlement rates went up and participant satisfaction in the process went up too. And one of the ways that happened was they structured the system so that instead of someone getting to, you know, give a 3-page explanation about why it is that they didn't like the item they were buying, you know, they had limited options like, well, the item wasn't as described, the item didn't arrive, and a system was able to facilitate participants basically understanding how that would resolve under the binding rules of the system in a way that made sense to everyone, and they were able to come to an agreement. There are a wide range of tools that can either automate neutrals, and some of these are being done with smart contracts, which makes sense because you have a technologically sophisticated group of people who are often skeptical of conventional dispute resolution things and sort of more trust AI to solve problems for them. You know, those people, I think, are sometimes unfortunately surprised when smart contracts don't go the way everyone thought they would, right? You have engineers now thinking they can do better contracts than lawyers, and maybe they can, but complex systems break in complex ways. And, you know, where, you know, having an AI adjudicate a problem for you may sound good in theory, but, you know, has a lot less flexibility and common sense than a human mediator. So for significant disputes, you know, probably in the near term, we're going to see is more augmentation of parties and neutrals by AI. So there's systems like CyberSettle or Smart Settle One, where an AI system can help with negotiation, with, you know, finding out that the parties have secret kind of bottom lines that overlap with each other and help the parties in gap bridging. And that's something that parties can do. You know, someone asked, can you do this, you know, with fewer lawyers or neutrals? You know, for low value disputes, parties can go on now and use these online mediation tools to help bridge gaps without communicating directly. They can also help parties and neutrals kind of come up with gap bridging solutions, and not just for monetary amounts. A lot of these are used in family law with things like visitation rights and so forth. There's also a role for these systems in educating lawyers, you know, in talking about confidentiality and knowledge asymmetry. You know, someone is bringing a personal injury claim for this sort of thing. You know, you can have an AI system have a database of access to decisions over the past 15 years in a particular jurisdiction and say, you know, here's the average case value, here's the time towards resolution. It can help parties with reality testing their positions. And parties are often, you know, whether or not they're mistaken in believing this, you know, will attribute more weight to things that appear to be technologically neutral. So these systems can have a subtle and a pretty significant direct influence on negotiations or even in arbitrations. And I think it is something that parties should be familiar with because it's likely to take on a growing role.
Thanks, Ryan. That's helpful. Alan?
Yeah. Thanks, Darrell. Well, I think as you all know, Huawei is a technology company, and we sell computers, servers, network gears, and so we definitely, are pro technology and, pro use of technology in whatever businesses, including dispute resolution. So we encourage the use of, remote systems for hearings. But I think there are many ways to use technologies in the back end in dealing with IP-related issues, and it has been for years that patent engineers use artificial intelligence of some kind in searching priors. For example, the semantic search had been used for over a decade to identify the priors. And I don't have the statistic, but I would my sense is many of the priors are and growing percentage of the effective priors are searched and found by advanced AI-based search engines, and also AI can be used in more sophisticated areas in terms of standard essential pattern. For example, we know initiatives and companies are trying to use AI-based engine to build up landscape reports for standard essential patterns in terms of, for example, 5G, 4G, this kind of cellular standards. There are so many patterns and very complicated standards, and the artificial intelligence can help to decide the landscape of the patterns, who owns whatever percentage, and the value of the patterns. Really, the AI engines are used now to try to match the patterns with the standards to see what patterns have a better match. So it's not perfect. I see that for the reports that I've seen, is may not be as good as what people can do, but it takes tremendous time for people to anybody to review thousands of patterns and build claim charts and really decide the essentiality of the pattern. So the AI tool, I think, as it's been evolving, it will be more and more helpful in that regard as well. I think I also wanted to note there are discussions and researching being done in using blockchain to tie up with the pattern assets. Nowadays, if you are dealing with, for example, pattern transactions, you would note the assignment and the encumbrance is could become a very problematic issue, because when the patents are sold through several companies, each company sign up a few licenses, and these different licenses would have different terms, and some of the licenses have not just licenses but also standstill terms that travel with patents, and so and there are also front obligations that need to be traveled through with patents, and there are many license issues that would travel with patents. So blockchain would be an ideal tool, as some gathered, to track down those information along with the transaction of the patents. And Huawei, in particular, as we are thinking more of our license to all strategy, as we are licensing to multiple levels of the value chain, chipset, and module, and end user product again, and it will be difficult to track the license. When for example, a chipset is sold to its customer, to its module customer, and when the module is embedded into an end user product, how can we decide the end user product is licensed? So the blockchain can be used in that regard as well. So I think there are many ways for us to use the technologies for our IP world. It will take some time, but I think it will gradually be adopted as these technologies are being adopted in our society in all areas.
Thanks, Alan. I'm going to shortly bring this session to a close by inviting every member of the panel to think about and share one takeaway that you want the audience to know, whether it's the impact of geopolitics, whether it's the impact of technology, or something else that might be more localized, that your jurisdiction might be offering that people might not be aware of, or that you might be offering that people might not be aware of. But before that, I just want to quickly ask Ryan. Ryan, if you haven't been following, has been on a worldwide crusade to get the machine to be recognized as an inventor. Now, so far your crusade has brought you to places like South Africa, like Australia, like the US, like Europe, but not China or Singapore. Now, can you reflect on your journey so far from a dispute resolution point of view, and whether Asia might be next?
Well, thanks, Daryl. I appreciate you bringing it up. As you mentioned, I've been leading a group of pro bono legal test cases on AI and whether an invention made by an AI can be patented. And part of that is who or what would be the inventor for it. And, you know, different jurisdictions have come to different decisions about this. So in the US and the UK, you have to do something really very specific to be an inventor. You have to have conceived of or devised an invention. In our case, we did not have a human being who, according to traditional criteria, conceived or devised of this invention. And so courts have thus far in the US and UK held that that patent, that you can't have a patent on an invention without a traditional human inventor. We just had a Court of Appeals decision that held, you know, an inventor could only be an individual under US law, which the US Patent and Trademark Office agreed meant that we had an unpatentable invention. We are planning to file a petition for cert on that, which is due in about 80 days. So we will see what happens. The UK, we had a Court of Appeals decision and they split 2-1. Justice Burse, who's relevant because he did the Huawei Unwired Planet case, where he was setting a global FRAN rate, thought that we should get a patent, but Justice Arnold and Lady Justice Lang disagreed. That's under appeal right now to the Supreme Court. We will see how that resolves. But the European Patent Office in Germany recently decided that you could have a deemed inventor. And so we had a decision of the Legal Board of Appeals in Europe recently where it said an inventor can only be a natural person, but if an AI invents something, you can just list the owner of the AI on the patent as in the specification that it was invented by an AI, and that would be fine for us. And Germany's court came to the same conclusion. So that is one way to protect this. The German Patent Office is appealing that decision to the German Supreme Court. And we had a judge in Australia rule that under the Australian Patent Act, and that at least in our case, the owner of the AI was the person entitled to that patent. That decision was overturned by a full court of the Federal Court of Australia, but that is also under appeal now to the High Court. So we will see how these things continue to evolve. We have filed the patent in China, in Taiwan, in Japan, and in South Korea. Sadly, I could not get anyone on board with doing Singapore at the time because all of the attorneys involved in this are working pro bono. The patent is still within patent offices in those jurisdictions, though. So I think that this is a topic.
You've got 2 patent attorneys here that you can talk to after this.
Well, indeed. Sadly, I think the nationalization deadlines have passed on that. But if only we had been speaking earlier, you know. But I am optimistic. You know, you had a copyright case with Tencent a couple of years ago for something that they had said an AI had written on their news service, and a Chinese court found that there was enough human creativity involved to call some of the programmers authors of it. But this is something we're seeing right now with AI generated art, which just this year, you know, AI has been making art for decades, but just this year has gotten so good. It's all over the internet, and you can have DALL-E 2 or a number of art generators generate some really very good art from just a sentence that you write. And there's going to be big commercial challenges with whether and to what extent you can protect that sort of thing, because courts and legislatures are all over the map right now and haven't really gotten to this issue the way it needed to be discussed.
Great, thanks, Ryan. And just very quickly, what's your one takeaway for the audience?
My one takeaway is I think a lot of the commercial challenges we've heard about today have a lot to benefit from for ADR. You know, almost always mediation and usually arbitration for the parties makes a lot more sense than conventional, you know, US style litigation. And that technology has and will have an increasing role in helping to streamline and improve the process for people.
Great, thanks. And I'm going to request 5 minutes of grace so that folks on this call can all have their thoughts after the time, the remaining 3 minutes ends. So, Bill?
The one takeaway I would mention in terms of mediation of trademark disputes, and I always tell the participants this, less than 2% of trademark litigation ends up going to trial. So 98% of the cases get settled, and I like to tell the parties, this is your best chance right now to do this and get this case over with and get back on a business relationship. Something for them to remember.
Thank you, Bill. Chiao.
Thank you. For me, I would say open our mind and try to use ADR in a flexible way. So actually, no matter mediation or arbitration, even expert determination, those type of ADR, including also litigations, these are the things these are the options we could use to resolve disputes. So sometimes trying to think in a more dynamic way, we can use one particular way to resolve the disputes, or sometimes we can use both or even 3 types of disputes resolution mechanisms. We can combine them. So all those are about strategies. So we need to know more about ADR and trying to use it in a flexible way and best suits our needs.
Thanks, Chiao. Barbara.
Well, I would just say that yes, there's no question that ADR has many attractions for parties in many kinds of disputes. As an academic, I guess I would just make sure that we still have voices maybe from academics pointing out that in IP, it isn't just about the parties. There is a public interest. Possible, but there are estimates about 30 to 50% of declared SCPs are either not valid patents or are not standard essential. And there is an interest to the public, there's an interest to other competitors to have that information out in the public domain.
Thanks, Bob. Joyce? Unmuted, Joyce.
Sorry, I was on mute. I think given that the audience at this session today, as I understand it, is mostly from outside Asia, presumably many with interests on a global scale, I would say the takeaway I'd like to share is get to know Singapore a little bit more. There is very good reason why the statistics have made this little so relevant to the international dispute resolution scene. And if you dig a little bit deeper, you'll find that the reasons are very practical, all the kind of considerations that disputed, which is really a system which is easy to understand, the convenience, the regional hub and global hub that it is, the convenience of language, the reliability of the rule of law, the neutrality of the jurisdiction, the predictability of doing business, all that stuff are just practical. If I sound like I'm making a plug for Singapore, I'm not. And the reason why I'm not is because the reason is objective. So I'll say for many of us who may not know Asia as much, and who are beginning to do business in Asia, it's probably good to know you have a friendly sort of venue for a dispute resolution hub, in this little island that Stanley and I are speaking from, and even Chiao. So that's my big takeaway for the audience.
Thank you, Joyce. Alan?
Yeah, well, I guess my takeaway, obviously, is that we should be filing more patents in Singapore, for the reasons that Dr. Lai given us. This speedy proceeding, would be very, very useful for the patent owners. Thank you.
Thank you. You made his day. And Stanley, you have the last word.
Thanks, Daryl, and thanks everyone. It's been a great panel. I really enjoyed couple of hours with you. Just to augment what Joyce is saying, come to Singapore. I mean, if you just look at the substantive law, we're starting to deal with notions of property in relation to NFTs. The one case which I thought we would have time to talk about, but maybe that has to wait to the next seminar, is the possibility of actually getting an injunction to block the sale of an NFT which had been used as collateral in relation to a loan of cryptocurrency. So that's one recent example. That notion of applying property concepts, whether chose in possession or chose in action, is continuing, and I think Singapore courts are actively getting to these discussions. So I think that's a very interesting space. The other segue is also to see how NFTs now can be a means to actually effect service or process in crypto wallets. There's at least one decision from the UK and one decision from the US that would permit this, and I think it just shows how even in dispute resolution, the filing of process and the service of process are also going beyond conventional channels. So watch this space and stay safe.
Great. Watch this space and stay safe. And with that, please join me in thanking the panel for their great insights, for their thoughts, for their time. And over to you, organizers, Adam, Gary, Rina, Ignacio. Thank you for the opportunity to be part of this conversation.